All right, explosive new details about the Tulsa County Reserve deputy charged in the deadly shooting of an unarmed fleeing suspect this month. A 2009 internal inquiry found that the sheriff's office violated training policies and gave Robert Bates special treatment, with some supervisors intimidating officers to disregard policies to favor Bates. In an exclusive interview last night, Bates' attorney talked to CNN's Anderson Cooper about the report.
Clark, the details of this report are pretty stunning. I mean, the multiple officers, police officers and employees with the Tulsa County Sheriff's Office were intimidated into giving your client special treatment and even falsifying his training records. Do you dispute that?
Yes. Yeah, the report speaks for itself, but this was after a few months that he'd been on the job. Keep in mind that reserve officers come in different varieties of experience. Some of them come directly from a police department that have had a number of years of experience and into retirement become a reserve officer. Some come from public life that have no police experience at all. Mr. Bates was a former police officer, but 30 years earlier he was CLEAT certified and authorized to be a police officer in Oklahoma.
From 30 years ago.
Yeah, but lacked the training. So he was in a different category, and when he was received into the department, there was some level of concern and some jealousy, I think, and that was voiced to the superiors, and it was reviewed. I think the institution responded appropriately, did interviews, did an investigation, and took corrective action.
I feel like we haven't read the same report, because I've read now multiple police officers who gave testimony in this report here saying that they were pressured because of your client's friendship with the guy who ran the department, pressured repeatedly to initial documents that they hadn't even written, but made it seem as if they had written, saying he doesn't need to get the full hundreds of hours of training, basically pressuring the timeline of the training. You say it was kind of petty jealousies. These are seasoned police officers who have given testimony saying, and are quoted in this report, saying time and time again, we're talking about sergeants and corporals who are saying time and time again, your client didn't have the training.
That's just a flat-out misstatement of the report. I know the individuals involved, and I've spoken to them currently. And the one person that had
Corporal Warren Crittenden was asked to initial documents that Bates didn't, that Bates had gotten enough training, documents he didn't write.
Yeah, Corporal Crittenden was terminated a year later for improper conduct as a result of Mr. Bates's report. He's now standing for first-degree murder in another county, represented by the lawyers of this family. And what you just quoted is just a misinterpretation and a misquoting of that report. There weren't numerous seasoned officers saying that. There was one officer, and one officer that said that he felt that Mr. Bates was getting special treatment.
All right, so Bates maintains that he shot Eric Harris by accident, mistaking his handgun for a taser. Joining me now, retired LAPD Police Sergeant Cheryl Dorsey and criminal defense attorney Joey Jackson. All right, good to see you back. So now, the attorney maintaining that Robert Bates did indeed have sufficient training, had the credentials to be in a position in which he was in. So, Joey, how might this impact the case against him? Because he is looking at charges as it relates to this man's death. At the same time, Mr. Bates is being allowed to vacation in the Bahamas while this case continues. He got permission from the judge in which to carry on with a trip to the Bahamas while this investigation continues, and while he is now facing time in trial to defend his case. So how is all of this, kind of impacting the case?
Fredricka, let's address it in four different parts. Let's first start what you talked about, which is the vacation. Now, let's put this in perspective. I represented a law enforcement officer in New York last year, and his father died out of the country. He was not permitted, based upon him facing charges, to leave to go to his father's funeral. So here we're talking about someone who was permitted to go to vacation. Should people be outraged? Well, they should be, because based upon my experience as a prosecutor and a defense defense attorney, I haven't seen that. And for people to have confidence in the system, they have to feel that the system applies to everyone. Step 2, regarding inadequate training. Obviously, it's important, it's relevant. What training did he receive? When did he receive it? And if anybody forced, coerced, or otherwise pressured someone to change anything, if that happened, then there should be consequences for the people who had that happen. Step 3, in the event that he had proper training, but there apparently are complaints about his performance, that also affects the case, because someone who could be properly trained can still be not competent to be out there. So that's relevant. Final step. Let's say, Fredricka, that he's found to have all the training imaginable, that he couldn't have had any more training than he had. It still does not address the underlying issue of how you mistake a taser or a gun for a taser, one being on your chest and one being at your sidearm. And so still, if he had all the training in the world, we have to still examine and say, you can still be culpably negligent, that it's so careless in regard to the standards that you use, that no reasonable person under your circumstances would exercise that care and still criminally responsible. So even if he did have the training, but he acted negligently, that doesn't bode well for his criminal case, and it certainly doesn't bode well for the civil case. So in conclusion, training, very important, very relevant, very significant, but even if he had the training, you still have to be held to a standard of reasonable care when you're dealing with people's lives.
So then I wonder, Cheryl, where do you see the importance of training here, whether it was 30 years ago because he was an officer or whether it was recent training, and to Joey's point, whether it was inadvertent, a mistake, or just simply rusty to not be able to discern the location of a taser on the chest and the pistol at the hip?
Well, let me say this about training, Fredricka, because first of all, he was a police officer in 1964 and he left the department in 1965. So I'm wondering if they didn't discover something back then, 30 years ago, that let them know that he was not properly situated to be in law enforcement, and so he leaves, and then he comes back 30 years later. And let's understand that the force that was used was only exacerbated by his poor training, by his own admission. He uses his personal vehicle for traffic stops. He issues citations. He's using a gun that he's not allowed to use and trained with properly. And so understand this, and let me put this myth to bed, that when a suspect runs, as Mr. Harris did, that the force that was used was excessive because it was not about controlling him. It was not about him resisting arrest. It was about punishment. That's what happened in the case of Freddie Gray. That's what happened in the case of Walter Scott. And that's what happened here. They wanted to punish these people because they ran from the police. Contempt of cop. There's a penalty when you run, and it's been death.
All right. Cheryl, Dorsey, we'll leave it right there. Joey Jackson, thanks to both of you. I appreciate it. And again, of course, we are watching the protest that will unfold later on today in